Hello everyone. In this video we will discuss regarding rules of delivery. Whenever the goods are delivered from the seller to the buyer, various rules are applied, and these rules have been discussed in this video one by one. The first one is delivery of the goods as agreed upon. The first rule says that whatever has been agreed upon mutually between the parties, that is buyer and the seller, the same things should be delivered. So whatever manner has been decided regarding the delivery, how the payment is to be made, when the payment is to be made, all these things are mutually agreed by the parties. So the goods must be delivered according to the terms that have been decided between the parties. Second, Section 33 of Sales of Goods Act 1930 states that there are three modes of delivery. As we have discussed in the previous video, there are three modes, that is actual delivery, symbolic delivery and constructive delivery. So delivery to anyone other than the buyer or his agent is insufficient. The goods are put in possession of the buyer or his authorized agent. So that should be made to only and only to buyer or his agent, not to a third person. And the mode, as we have already discussed about three modes, any of the modes can be chosen. Third is payment and delivery are concurrent conditions. Section 32 of the Act says that if nothing has been decided between the parties, then the delivery of the goods and payment should be concurrent. Concurrent means side by side. The seller should be ready and willing to give the possession, that is delivery, and the buyer should be ready and willing to pay the price. Only then we will say the delivery is a valid delivery. Next comes effect of part delivery. Section 34 of Sales of Goods Act. This section says that when goods are delivered partly, so what will be the effect of such part delivery? So there are two cases which can be discussed under Section 34. First is part delivery in progress of the whole delivery. If that part delivery is in the progress of the whole delivery that will be coming soon, so here part delivery means full delivery. I repeat, in this case part delivery means full delivery. For example, you can see this case in front of you. The buyer duly got total 100 kg weight properly and takes away 20 kg. So 100 kg has been weighed by the seller and the buyer takes the 20 kgs out of the total. Later on the fire occurred and 80 kgs were destroyed. Now who will be responsible for this loss? Now as the 20 kgs were delivered and they were in progress of the whole 100 kg, so it will be considered that part delivery means full delivery. Part delivery will operate as the delivery of the total and the entire loss of 80 kg will be belonging to the buyer. The second case is when part delivery is made to swear it from the whole. When we want to separate a particular commodity from the whole lot, in that case part delivery will not mean full delivery. If we take the previous example only, in that the buyer has not weighed total 100 kg but buyer has weighed only 20 kg. And he take the delivery of that. Such a part delivery was made intentionally to take the delivery of 20 kg only. So it means that here the motive is to separate that 20 kg from the lot. Unless if the 80 kg are again got by fire in this case, so that 80 kg's loss will be belonging to the seller, not of the buyer. So general rule says that part delivery means full delivery, but when the objective is to separate the goods from the lot, in that case part delivery will not mean full delivery. Next is buyer must apply for the delivery. So in the absence of any express contract, the seller is under no obligation to deliver the goods, but buyer has to apply for the delivery. So when the goods are subsequently acquired by the seller, he should intimate the buyer that goods are ready for delivery. If the buyer does not apply for the delivery, the seller is under no responsibility to give the delivery. Next is place of delivery. Section 36 subsection 1. Now what is where the goods have to be delivered? It will depend upon various cases. Now if the parties have decided regarding the place, that is very much fine. On that place only delivery will be given. So when the parties have mutually decided. Second, if the parties have not mutually decided, then for a contract of sale, the goods will be delivered at the place where the contract was meet. So where the contract of sale was designed, at the same place the delivery of the goods will be made. But in case of agreement to sell, so where the agreement to sell was designed, the goods will be delivered at the place where they are at the time of agreement to sell. So when the parties have decided, there is no issue. When the parties have not decided, then law says in case of contract of sale, at the point when the contract was made, and agreement to sell, where the agreement was made. So in case of future goods, the place of delivery is the place where the future goods are going to be manufactured. Now what is the time of delivery? Section 36 subsection 2 states that under the contract of sale, the seller is bound to send the goods to the buyer, but no time was fixed when the goods will be sent. In such a case, it should be delivered within a reasonable time and within reasonable hours. Hours means when the working hours are there in the day. So now what is a reasonable time? It will depend upon case to case. So delivery has to be made within a reasonable time. If the parties have decided, then there is no issue. Next comes point number 8, section 36 subsection 3. This point deals with manner of delivery. So when the goods are in possession of a third party is holding the goods, there is no delivery by the seller to the buyer unless and until such third party acknowledges to the buyer that he holds the goods on his behalf, like we have done in case of constructive delivery. The same is the case here. So just see the example. A's goods were stored in warehouse of X. A sold this goods to B. A informed X that the goods now have been sold to B. Now X shall store the goods on behalf of B. But X never acknowledged this fact to B, that goods are now belonging to you. So later the goods were destroyed in the warehouse due to fire. X held liable B for the loss, but B was not liable as the same was not acknowledged. So the delivery which has been made to a person, although the goods are lying there only, but that has to be acknowledged that from today onwards goods will be belonging to you. Next comes who will be bearing the expenses of delivery. Section 36 subsection 5 deals with this. It says that unless agreed, the expenses of putting the goods into the deliverable state, to put the goods in the ready for delivery, it will be borne by the seller. In case the parties have come to some agreement with respect to cost of putting the goods in deliverable state or expenses, there is no issue, then that the decision will prevail. But if nothing has been decided, so it is said that till the point of putting the goods in deliverable state, the seller is responsible, and the other expenses, future expenses, that receiving the goods or incidental charges, that will be borne by the buyer. Next point is delivery of the wrong quantity. If wrong quantity has been delivered by the seller to the buyer, section 37 deals with this. This section says that it is the duty of the seller to deliver the right kind, right type, right quality, right quantity of the goods. But in case he delivers a wrong quantity, then what to do? In that case, you will see whether the goods, there can be three cases here. The goods can be of shortly deliver. It means whatever the quantity was asked, you are giving a lesser quantity related to that. So in case the lesser quantity is being given, so the buyer has an option. He can reject the goods or he can accept also. All this depends upon the discretion of the buyer. So law has given the right to the buyer. Second comes when there is excess delivery. The goods have been supplied in excess. It means if you have asked for 100 kgs, you have been delivered 200 kgs. So here what are the rights to the buyer? There are three options with the buyer. He can accept the whole. If he does so, he will have to pay the price for the excess also. Second, he can accept the goods which he wanted and he can reject the excess goods. And third is he can reject the whole lot. So three options have been given to the buyer. He can take whatever he has ordered, he can take the whole, or he can reject the whole. And the third case in this situation comes mixed delivery. Mixed delivery means whatever you have asked, some other things have been mixed into that. So what the buyer can do is, first the buyer can accept whatever he has asked for, take out that, and then can reject the rest, or he can reject the whole. So when he finds that it is easy to separate, he can accept what he has ordered and the remaining he can reject. Otherwise he can reject the whole lot also. Nobody can challenge him. Next comes delivery through installments. Section 38 deals with it. It says that in the absence of contract to the contrary, the buyer is not bound to accept an installment. If the parties have decided, then it is okay. Otherwise, the buyer is not responsible that he will be accepting in the installments. So the performance of the entire contract can be split up only with the mutual consent. If there is no mutual consent, then the delivery cannot be made in installments. So whenever now see where the parties to the contract agree, then the delivery shall be made in installment. But where nothing has been agreed upon in the party, then buyer is not bound to accept the delivery through installment. It means he can reject it. Next point comes delivery to the carrier or the wharfinger. Carrier or the wharfinger is like a middleman who will be accepting the goods on the behalf of other person. So whenever you are giving the goods to the carrier, there are three possibilities, three cases we can discuss here. First is section 39 subsection 1, when the delivery to carrier is delivery to buyer. It says that when according to terms of the contract, the seller is delivering the goods to a carrier, then delivery of the goods to the carrier means delivery of goods to the buyer, because this thing has been discussed already according to the terms. Therefore, once the goods have been delivered to the carrier, the property passes to the buyer. If the goods are suffering from any loss, it will remain the loss of the buyer. Now, second possibility is contact with the carrier is must. Section 39 subsection 2 says that when the seller is to deliver the goods to the carrier, he must form a contract related to this, that he should try that safety has to be there, the goods are safely transmitted to the buyer. So with the carrier he has to make a contract. Such a contract is essential so as to save the seller from any loss that may occur to the buyer when the goods are in the custody of the carrier. So he can create a contract like that. If anything happens to the goods, buyer will not be responsible, you will be responsible. In other words, the seller delivered the goods to the carrier without making a contract, like for safe delivery. With the carrier, the goods suffered from any loss. In that case, buyer cannot be held liable because seller has not made a valid contract with the wharfinger or with the carrier. In that case, the seller will himself be responsible. So in such a situation, buyer can decline and can treat the delivery that it has not been made to him. Third is delivery through a sea route. Section 39 subsection 3 says that where the goods are sent by the seller to the buyer through a sea transit, then it is the duty of the seller to intimate the buyer that goods need insurance. So without insurance, the goods cannot be sent through the sea route. So if the seller fails to do so and the goods suffer from any loss, then of course the entire loss will be belonging to the seller. Next is delivery at a distant place. Section 40. Now if the seller at his own risk agrees to deliver the goods at a place other than where they are at the time of contract, so the goods deteriorate in the course of transit, then in such situations, the loss of deterioration during the transit will be borne by the buyer. So this is the rule under section 40. When the goods are to be delivered at a distant place and the buyer is agreeing upon it, so it means the buyer will have to take the loss of that also. Next is delivery of the goods subject to examination. There are some goods which the buyer wants to examine. So that comes under section 41 of the Sales of Goods Act. It says that buyer has a right. He can examine the goods before taking the delivery. Unless he is given the opportunity to examine the goods before giving the delivery, he will not accept the goods. So when the buyer has already told that he will be examining the goods and the seller is not giving him the right to examine the goods, the buyer can reject the goods. Then acceptance complete on delivery. Once the goods are being given, the buyer will accept the delivery. It means it is said that contract is complete. So when the buyer is said to have accepted the goods, when the buyer intimates expressly that I have accepted the goods, or buyer does something which implies that he has accepted the good. For example, he resells them or he pledges them or he consumes them. So it shows that he has accepted the goods. Buyer retains the goods and do not reject and return them. It is implied that buyer has accepted the goods and delivery is complete. Next is buyer not bound to return the rejected good. Now this is a very interesting section, section 43. It says that it is not necessary that if wrong goods have been delivered to the buyer, he need to reject. When the buyer rejects the good, then he must intimate about his rejection. He will have to tell that I want to reject the goods to the seller. But it is not the duty of the buyer to send the goods back. So it is the duty of the seller. Okay, so seller will be taking back the goods. It is not the duty of the buyer to resend them. So it is duty of the seller to take away the rejected goods. Liability of the buyer for rejecting or refusing the delivery. Now here the buyer is refusing a right delivery. Here we have told that buyer have received the wrong goods or more quantity, then buyer can reject. Here we are saying the buyer is refusing the delivery. So where the property in the goods or ownership rights have been passed on to the buyer has to accept the goods, because whatever you have asked, it has come to you, so you have to accept the goods. Now seller offers the goods to the buyer and buyer refuses to take the delivery. So what is the now point here? Buyer shall be liable to the seller for any loss due to his refusal, because the goods are now going back. Again, the seller will have to bear the loss for that. So in these cases, the buyer will be responsible. So these are total 17 rules we have discussed regarding the delivery of the goods. So whenever you want to make a valid delivery, all these rules have to be followed by the parties. Thank you so much.